Hello, this video will be explaining sentencing law in Canada as well as its history, its legislation, how it relates to the Canadian Charter of Rights and Freedoms, sentencing law cases, and how each side in the political spectrum view sentencing law. First and foremost, what is sentencing law? Sentencing laws are the laws created to determine the punishment of a person who commits a crime. The severity and extent of the punishment can vary due to certain factors. These factors are called aggravating and mitigating factors. Aggravating factors can increase the sentence, and mitigating factors can decrease the sentence. Previous criminal offenses, previous jail time, level of how much the victim was harmed or impacted, and to what extent the crime was planned are all examples of aggravating factors. Some examples of mitigating factors are low risk of the offender committing another crime, if the crime was an accident, if it was the first time the offender committed a crime, cooperation with authorities, and remorse. Even though there are mitigating factors to reduce the severity of punishments, the law can still be unjust in some cases. If the laws that protect the victim are too strong, then the offender will get an unfair punishment. Likewise, if the laws that protect the offender are too strong, then the offender will not get the punishment they deserve. Another way the law can be unjust is when the judge holds biased views against either the victim or offender. Judges are known to be honest, just, and trustworthy. However, they are still humans and will have biases like everyone else. For example, if a judge had a family member who was affected by a crime, or if they have strong beliefs against a certain crime, they will sentence that crime harshly if they encounter it in court. It is also possible that a judge may be racist or stereotypical towards a certain race or religion and sentence those people unfairly. So we know that sentencing law may be unjust, but how can it be fixed? Well, the obvious answer would be to allow only the best and most honest people to be involved in the work of law. All lawmakers, politicians, and judges should be the best of the best. Only then will there be no corruption and a just system. However, to answer this question completely, we need to look into the past. How was sentencing law created, and why is it the way it is? Sentencing law was created from ancient legal systems when the society wanted people punished for committing crimes. A just system was needed to determine the punishment of an offender. This started with codified laws such as the Code of Hammurabi. Some legal systems also had courts to deal with issues that the codified laws did not mention. Ancient Greece was one of the first places to adopt the court system. Each legal system was lenient on some laws and was strict on others. Some people of the time viewed certain sentencing laws as unfair, while others supported it. It came down to the beliefs and morals of the people, and that was what created the law over time. Newer generations had slightly different morals and beliefs than older generations. So they didn't agree with old laws. Over time, old laws were omitted and new ones were created. This caused the law to be ever-changing and created the law we have today. Certain situations would also cause the law to be changed. Let me give an example. Suppose there is a legal system that does not have a court system. They completely rely on codified laws to sentence offenders. Now, a person steals a farmer's fruits. The farmer suffers heavily from this and can't provide for his family. Because this event took place, a new law would be created stating that a person may not steal another person's fruits. Now, we know how sentencing law changed, but has it improved? Well, everyone has a different view on this based on where they stand politically. However, most people can agree that one of the greatest changes in Canadian sentencing law was when the death penalty was abolished. Previously, people were hanged or shot for committing certain crimes such as murder. This shows how Canada's sentencing system now also focuses on rehabilitation and not only retribution. Now we will be taking a look into the legislation of sentencing law. The legislation of sentencing law refers to all the laws, acts, codes, and statutes relevant to it. Legislation has a big part in sentencing law, as many pieces of legislation are regarding certain crimes, and those pieces of legislation have a minimum required sentence. So when a person is sentenced for a specific crime, the legislation for it is reviewed. An example of sentencing legislation is the Truth in Sentencing Act. Its objective is to not allow parole for people in prison, meaning that a person has to serve his full sentence with no chance of shortening it. Another legislation is conditional sentencing. Conditional sentencing is when a person does not have to serve time in a correctional facility, such as a prison, and can rather do community hours, be on house arrest, or be on probation. Perhaps the largest piece of legislation regarding sentencing law is the Criminal Code. Certain criminal offenses in the Criminal Code can have a range of punishments that could be carried out. The sentence is ultimately decided in court when the Criminal Code is looked at along with precedent.
Now we will be taking a look into another piece of legislation, the Canadian Charter of Rights and Freedoms. The Charter of Rights are by definition a list of rights that all Canadians have. These are all integral to the sentencing process. If any are violated, then it can change the sentence. In a sense, the Charter of Rights protects people so that they are not wrongfully sentenced. For example, a homeless man is normally walking down the street and police, with no warning, stop him, throw him to the ground, and hold him in custody. This is violating multiple of his rights. Section 9 states, you have a right to freedom from arbitrary detention. He was held in custody for no reason. There was no reasonable grounds. It could have been prejudice from the police just because of the way he looked. Section 7 states, you have the right to liberty, life, and security. His security was violated, and the police could have hurt him and caused distress. This is obviously a very extreme case, but in this situation, there would be no sentence or punishment, as his rights were violated and no crime was committed. Sentencing can work more effectively if Section 8, which states the right to freedom from unreasonable search and seizure, is enforced more effectively. Many people in authority will judge someone based on their color of their skin and or what clothes they wear, and they need to stop. It should not matter what the color of their skin is. One of the most important sections is Section 12 of the Charter. This is the section that protects an individual's freedom from cruel and unusual punishments. Whether a sentence is cruel and unusual depends on whether the sentence is grossly disproportionate, which requires that it be more than excessive or unfit. It must be so excessive as to outrage standards of decency and disproportionate to the extent that Canadians would find the punishment abhorrent or intolerant. This ensures that people are not sentenced to punishments that are more harsh than the crime they committed. It is to keep things fair and decent. A case is the information on a person that will be used in court to be proven innocent or guilty. This includes fingerprints, weapons, and information about the scene of the crime, and etc. It is the job of the investigator to find the truth of what happened using the evidence gathered. In Roman and Greek times, judges had all the power. It was a very corrupt system, as judges could be paid off, and you weren't even allowed to represent someone in court until much later. An example of a corrupt judge and their influence is Judge Mark and the Cayaverala's Kids for Cash scheme. The man sent thousands of kids to juvenile detention for things like stealing a mom's car and driving down the block. The court eventually realized that the detention center was paying him every time he sent a kid there. In these extreme cases, corrupt judges do have the power to do horrific things. This is very uncommon, but it highlights how judges do still have a fair amount of power in court proceedings. Unfortunately, in today's society, there are racial biases, and in situations where a black man is accused of something, no matter how well the defense proved their case, an all-white jury who might be racist could put the man away for something he didn't do. Reuben Hurricane Carter was an American-Canadian middleweight boxer who was wrongfully convicted of murder. In 1966, police arrested Carter and friend John Artis for a triple homicide. The police stopped Carter's car and brought him and Artis also in the car, to the scene of the crime. The police did not take fingerprints at the crime scene and lacked the facilities to conduct a proper gunshot test. There was no evidence that connected them to the murder area. Carter and Artis were tried twice for the murders in 1967 and 1976, and both convicted. Both served time in Rathway State Prison for 20 years. After the second conviction was overturned in 1985, prosecutors chose not to try the case for a third time. Detective Emile DiRobio, the lead investigator, had it in for him since he was born. His only reason to chase him was because of the color of his skin and his idea that all black people are dangerous and can never rise to success. The Supreme Court of Canada is an evolving thing, as all courts are. Imagine if you were still cutting people's hands off for stealing or putting someone on death row for talking bad about the Queen of England. In the old days, the social beliefs were different, and so the sentences and punishments of the courts reflected that changing was a hard thing for us to believe in. As time passed and more research was put into how the brain works and how extremely hard punishments like solitary confinement doesn't encourage people to be better, as well as the evolution of social values, precedent played a huge role in these cases. As there was a bigger influence on reform, there were more programs and opportunities for criminals. Who knows, maybe in the future there will be no more prisons, but real rehabilitation centers. Each party has different values and different ways of approaching problems, so it would only be logical if they had different views on how sentencing should work. The Conservatives in Canada want harsher punishments because they believe that you do the crime and you pay the time. NDP wants to remove mandatory minimum wages sentences, as every case is different and should be treated accordingly. The Liberals take a middle stance in where they want stronger gun control but more reform in a prison as punishment. As they do have different views on different topics, they would make laws that help their view. An example is that the Conservatives want to increase the sentence on crimes such as gang violence. Their solution is to have a 5-year minimum sentence on violent crimes and possessing a smuggled firearm. In conclusion, sentencing law plays an important role in our society in keeping it safe. It governs the area of law that determines the punishment of someone based on a crime they have committed in a just manner. The Charter of Rights and Freedoms makes sure of this by declaring the rights of all Canadians and does not allow for any abuse of power. But the laws are mediocre. People who commit crimes are put into jail respective of the intensity of the crime. But it does not excel. It does not reach for anything higher. Isn't the justice system made so that people who have made mistakes can correct themselves and learn from their mistakes? Instead, they come out worse than before and can rarely ever get back to how life was before and contribute to society. I believe for our laws to actually have a positive impact on people, we need to focus less on punishment and more on reform. Things like teaching criminals how to own up to their actions and start improving themselves. We as a society will only change if everyone starts changing. Thank you for listening.